Okay, welcome everyone to this panel discussion hosted by the Cambridge Pro Bono Project, or CPP for short. My name is Matthew Sykaris. I am a director of the CPP. By way of very brief background, the CPP is now in its 11th year. It's a research program run out of the Faculty of Law at the University of Cambridge. What we do is to partner faculty members and graduate research students with leading barristers' chambers, charities, and NGOs to produce research on issues of contemporary significance. And we also host regular talks. So tonight we will hear from three speakers on the topic of armed violence and the recording of civilian casualties in armed conflict. We'll also be launching a major report which the CPP has produced on that topic. So the aim of tonight really is to present information on why there is a need to record civilian casualties, what are some of the practical difficulties in doing this, and then what are states currently doing, and perhaps under law, what should they be doing if they're not doing it? So it's necessarily a high-level presentation of the issues, but hopefully we can get into some detail in the Q&A if the audience wishes. As a guide, each of our three speakers will talk for about 15 minutes, followed by a short overview of the CPP's recent report, and we'll then open up for questions. And please do send your questions through during the talk using the Q&A function. So without any more delay, I will introduce our panel. First, we have Ian Overton. Ian is the Executive Director of Action on Armed Violence, which is a charity that seeks to reduce the impact of armed violence through monitoring and research of the causes and consequences of weapon-based violence. Ian is a former BBC and ITN journalist whose reporting has won numerous awards and has worked in over 24 conflict zones. In addition to that, Ian has also published 2 books on armed violence. And Ian also sits on the advisory committee to the UK's all-party parliamentary group on explosive weapons. Our second speaker is Georgia Edwards. Georgia is the UK Advocacy Officer and a conflict researcher at Air Wars. Air Wars is a not-for-profit aimed at tracking, assessing, and archiving military actions and civilian harm in conflict zones. Before coming to Air Wars, Georgia worked as an assistant to a UK Member of Parliament and as an intern at the UNHCR. And finally, we have Gavin Crowden. Gavin is the Executive Director at Every Casualty Counts. Every Casualty is a not-for-profit focused on promoting effective casualty recording in situations of armed violence. Gavin has over 20 years' experience in senior positions in humanitarian INGOs, working on conflict-related issues. In the UK government, Gavin held a range of roles, including as private secretary in the Office of the Deputy Prime Minister and as the UK government's international climate finance negotiator in the EU and the UN. So we extend a very warm welcome to Ian, Georgia, and Gavin in Cambridge. As explained, each will speak for about 15 minutes. And I think we will start with an overview of the topic from Ian. Ian, please take it away.
Thank you very much. So, as Matthew very kindly introduced me, I run Action on Armed Violence. First, I'd like to point out that this has been a remarkable, heartening journey, and I'm very grateful for the Cambridge Pro Bono Project to really take on this area of concern, and hopefully the brief presentation I'm about to give about why we should be concerned is going to become self-explanatory. I'd also like to thank the University of Cambridge for hosting this. It means quite a lot to me. I studied both at Downing and at Gonville and Keys, so I'm sure I will now demand the Faculty of Law t-shirt as well. Action on Violence on a daily basis looks at English language media reporting of explosive violence incidents around the world. We do not claim that we will capture every single incident that will occur, but we do believe that we will look at patterns of harm and predictable harm that will occur around the world as a consequence of explosive violence. And we've been doing this for over 10 years. We started off in October 2010, and this year we launched our 10 years worth of data, a very mature data set. And hopefully I'll explain some of the key themes in this, and this might give a contextual reason as to why accountability and casualty recording is so important when it comes to explosive weapons in particular, but conflict in general. We looked at explosive violence between 2010 and 2020. Of the total reported numbers of deaths, we saw around 360,000 people killed or injured globally in that time. 73%, around 3/4 of them, were civilian casualties. It's probably unsurprising to people who follow international affairs that the global harm really peaked in around 2016 and 2017, when you saw the devastation that was coming out of places like Syria, but also a rise in violence both in places like Yemen and also Ukraine. But what we saw throughout the decade up to around 2016 was a steady rise. It has fallen in recent years, but still every single day we're seeing reports. And whilst the pandemic certainly quelled the amount of explosive violence globally, it seems to be seeing an uptick. So August this year was 86% more civilian casualties globally than August last year. It is a totally global phenomenon. We saw explosive violence being used in 123 different countries and territories. In terms of the deadliest weapons, improvised explosive devices constitute around 50%, and ground launch and air launch weapons were around 1/4 each. And it's air launch weapons that really capture my attention when it comes to British military engagement, although recent reports on mortar strikes harming civilians came out, and Action on Nonviolence last week did a report where we showed that 286 civilians had been killed by British military action in Afghanistan, where compensation by the MOD had been paid out. And some of those incidents did involve mortar strikes. In terms of the areas where we witnessed the most harm, populated areas stand out far above head and shoulders than any other area of concern. When explosive weapons were used in populated areas, 90% of those killed or injured were civilians in the last decade globally. And this figure we see repeated again and again, year in, year out. It's not an anomaly. It is almost a predictable percentage that we've seen every single year since our records began. And this explosive weapons in populated areas with 2,400 of the 240,000 of the 260,000 civilians killed or injured in the last decade occurred in towns and cities, in urban residential, in markets, and in places of worship. Indeed, when attacks occurred in places of worship, there was on average 31 civilians killed or injured per incident, with markets, unsurprisingly, also being a prime area where explosive weapons were used, an outcome. And yes, many of these were improvised explosive attacks, suicide bombers and the like, but we have seen some terrible incidents of airstrikes occurring. Indeed, if we looked at the worst incidents of the last decade, whilst it is dominated by things like a truck bomb in Mogadishu and suicide attacks in Sri Lanka, the third most injurious incident in the last decade was in Yemen in Sana'a, where 735 civilians were hit when an airstrike led by the Saudi-led coalition targeted an area that turned out to be a community hall. We've seen Russian-led bombings in Syria, with Duma witnessing 620 civilians killed or injured in 2015. Airstrikes in eastern Ghouta in Syria with almost 600 killed in 2018. Airstrikes again in Duma with 570 in 2018. And whilst the others are largely suicide attacks, the airstrikes and suicide bombings are the sort of twin hands of evil. It's primarily a very asynchronous form of warfare. You've got highly evolved drone strikes on the one hand and fighter missiles, and then on the other hand you have, potentially young brainwashed men blowing themselves up with a device that may only cost $20. In terms of air-launched attacks, we saw almost 60,000 people, civilians, killed or injured in the last decade. 90% of deaths and injuries in populated areas by airstrikes were civilians. And 5 of the 10 incidents that we recorded, 5 out of 10 incidents of all airstrikes occurred in populated areas. We saw airstrikes in 31 countries and territories. Compare this to ground launch. Again, you're seeing over 90% civilians deaths or injuries, a similar sort of number of civilians killed, but more ground launch weapons being used, which primarily is some countries don't really have evolved air forces, and so they may well be using ground launch weapons such as mortars against enemies and targets. And improvised explosive devices dominate it all. Again, 90% of deaths and injuries by IEDs were in populated areas, 100 territories impacted, and around 136 civilians killed or injured in the last decade. In terms of the worst affected countries, we have predictably Syria, where 84% of all casualties were civilian. We had Iraq with 77% of all casualties civilian. Afghanistan, slightly less, 58%. Pakistan, 70%. And Yemen, 68%. So in every single major country that you witness, the majority of those being killed or injured by explosive weapons are civilians. Now, particularly through the prism of the British military, we're very interested in airstrikes. Why is this? Well, primarily because airstrikes have been around for over 110 years now. We saw 43 different perpetrators of airstrikes over the last decade, and a very large number of casualties, 84,000. Obviously, many of those would be state actors, but nonetheless, are non-state actors and not civilians. But nonetheless, the lethality of airstrikes and the sheer weight, we're looking at 1,000 kilograms of a GB-10 Paveway 2 Mk-84 bomb, 1,000 kilograms fired from almost 15 kilometers away with a 360-meter radius. It is not surprising that when such a huge weapon lands in a town or a city, populated areas, civilians will be impacted. We witnessed 28 countries and the most bombed was Syria, Iraq, Afghanistan, and Yemen. And you witnessed, whilst there were 13.6% average total casualties per attack, there was 7.6 average civilian casualties per attack. So again, more than 50% of those killed or injured by airstrikes were civilians globally. And why does this interest us in the UK? Well, there is this absolute pall of silence over the predictability of such harm. Indeed, Action on Armed Violence worked with the BBC to release a report that claimed that whilst 4,315 enemy fighters had been claimed by the MOD killed or injured in Syria between 2014 and January of 2019, the RAF claimed they had only killed 1 civilian. The RAF have refused to reveal how many bombs failed to explode because they claimed it would harm the arms trade manufacturers' trade secrets and harm their reputations. The RAF has failed to record or even estimate how many civilians it's killed on operations. And also the RAF doesn't know how many civilians it has killed in wars abroad. So on every single level, the RAF seems to have failed and the MOD seems to have failed in recording casualties, despite it being absolutely apparent globally the impact of explosive violence on civilians. And just very finally, why this intervention and these legal recommendations are of real interest is because I work with a group called the International Network on Explosive Weapons, INEW, and we are trying to create a political impetus in the United Nations to get UN member states to sign up to say that they will not use explosive weapons in populated areas. It's not a prohibition, but it's a political commitment to act as explosive weapons in populated areas effectively being the last resort and something that is a taboo. And so this sort of work showing the responsibilities of the UK state to record civilians will help reinforce the fact that in modern warfare, the real victims will be and are civilians. Thank you very much.
Thanks so much, Ian. Sorry, I was on mute. I'm just going to share my screen. So yeah, thank you so much for having me today at such an important report launch, and thanks, Ian, for starting off. So I'm going to follow on from Ian and talk a bit more about specifically the problems of UK accountability and how this differs with some of its closest allies. So firstly, just a bit about air wars. So what we do, so we monitor instances of reported civilian casualties, locally reported civilian casualties from in conflicts in Syria, Iraq, Libya, Yemen and Somalia. We assess local claims of civilian casualties, we engage with politicians and militaries, and we investigate the broader trends of these. And so firstly, from our engagement with US and European militaries, we've actually found that over time the UK has been one of the most transparent militaries in terms of declaring strikes where they happen and releasing information on where they happen. So we know that the UK has conducted more than 1,700 RAF airstrikes in the war against ISIS. However, as Ian mentioned, the UK still only admits evidence of one civilian death in the whole of the US-led coalition conflict in Iraq and Syria. And it's this lack of accountability, so the refusal to admit or identify instances of civilian harm, which is the problem, and it's what I'm going to focus on today. And so we think that it's a systematic failure where either the Ministry of Defence won't admit or they can't admit. And so as part of our monitoring work of the US-led coalition, our specialists use our air wars methodology to monitor all locally reported civilian airstrikes. And so our findings suggest that at least 8,300, but up to 13,000 civilians have been killed in these strikes from the US coalition as a whole. And this includes from the thousands of British airstrikes that we know that they've declared themselves. And so we believe that a key reason for the failure, one of the key reasons anyway, for the failure for the UK to admit these is because of the exceptionally high proof threshold that they apply. So we know that the UK requires hard facts when assessing civilian harm claims, which is even higher than the UK courts, which use beyond reasonable doubt. And this differs in different militaries and Department of Defenses. So the US Department of Defense, they use a different threshold. So they use a balance of probabilities, which means they consider credible reports, much like the ones that air wars would give to them, and a balance of probabilities on whether an airstrike credibly or non-credibly killed civilians. So the type of assessment that air wars would flag with the US commands are based on our methodology. So that includes local language research, enhanced geolocations and an assessment, and we use a grading system. So here's just a bit more information on that. So this is the local language research that we would include. And this is also a bit about the grading system. So whether we would call it a confirmed civilian casualty fair, weak, contested, or discounted. So critically, we've even recently had a case where American military have shown that British airstrikes have killed civilians, but the UK is still denying this. So, for example, there are 3 events that we know of where strikes killed civilians, and we know that they were British strikes. But our question is, what is actually stopping the UK from admitting these deaths? And as Ian mentioned so well, that we also know there's huge global campaigns around the use of explosive weapons. And so we know that in the battles of Raqqa and Mosul, there was significant, and if not the most significant, periods of destruction and civilian harm. So in Mosul, we know that there were 750 RAF airstrikes. And we also know that in total, 9,000 civilians were likely to be killed in Mosul. However, there's still no admission from the Ministry of Defence on this. And so looking quickly at the obligations, so the Foreign Office and the Ministry of Defence have committed themselves to various standards. So for example, in the recent approach to the protections of civilians in conflict, the Ministry of Defence has said that they will investigate any credible reports that UK actions may have caused civilian harms. However, there's no specific legislation which actually compels them to do this. And warfare this is coupled with the fact that warfare has changed over the last 2 decades, which means that many of these operations have limited parliamentary oversight, which means that people either just don't know it's happening, or there isn't the incentive from the military to tell them that it is. And this differs from the US. So we think that I guess I've got the question for us is what is the incentive? And we kind of feel like this will only ever happen through primary legislation. So when we look at the changes in the US and in other allies like the Netherlands, it's always happened through primary legislation. And this is what we would like to see in the UK as well. So this differs from the US, where since 2018, there has been substantial improvements in accounting for and investigating instances of civilian harm. The Department of Defence has been legally required to report civilian casualties to Congress on an annual basis since 2018. So, for example, the most recent report admitted responsibility for 22 deaths, but previous years have been much higher. And before these changes, Congress had limited oversight into US involvement with the US-led coalition and other major conflicts such as Afghanistan and US counterterrorism operations. So we have seen a significant improvement. And this is just an example of the difference between accountability and transparency. So we see here that the UK is transparent in that they are declaring strikes, but what the US example is more accountable in terms of the fact that they're actually accounting for potential instances of civilian harm. We've also seen recent improvements within US military command. So they've established, for example, a permanent civilian casualty assessment team, the publishing of regular monthly civilian casualty reports, and also engagement with civil society organizations like Air Wars. And these policies are only currently within US military commands, but they're in the process of, we hope, being enshrined in law. And so for example, the Pentagon is currently concluding a 2-year review of these issues, which will hopefully become a Department of Defense instruction before the end of the year. And a lot of these changes do depend on the DODI we're going through. And another difference is that in the US, there's been a more openness for civil society to make these things happen, which we haven't seen similarly in the UK. So in the US, we remain a primary public reference for civilian harm events, so much so that 3/4 of all potential civilian casualty incidents currently examined by the US command have been flagged by Air Wars, and we've never seen the same level of engagement with the Ministry of Defence. And so, yeah, I guess our question is what is the incentive? And this is why we think that the change of primary legislation is so important to get political parties to take this issue really seriously. And I guess, so yeah, looking at the recent tragic US drone strike in Kabul at the end of August, which killed an aid worker and his whole family, we did actually welcome the admission and the investigation from the US. However, we have to say that this admission is an exception rather than the rule in Afghanistan, from the US and other allies. And there are, as you can see, there are systemic failures of all nations, but degree on which they are willing to concede civilian harm is different. So the US still obviously has a lot further to go, but they have taken steps. But there are still, of course, tens of thousands of civilians in the war on terror that haven't been accounted for. And this is our recent piece of work from our investigations team who tried to put together the number of civilians likely killed in the 20 years of the so-called war on terror. And so, yeah, roughly speaking, from our data, we think that the Americans have admitted 1 civilian death for every 40 airstrikes in Iraq and Syria, according to official data. So as you can see, the real number would be far, far higher. Whereas the British have declared more than 1,000 airstrikes in the whole of the US-led coalition conflict, but they've only declared 1 death. So we want to ask whether they found this huge breakthrough, which means that they aren't having the same number of civilian casualties, or if they're just getting it majorly wrong. And finally, Ben Wallace, the UK Defence Secretary, has recently made it clear that the UK would consider the use of remote actions in Afghanistan, citing that he'll do whatever he can to protect civilians' lives and our interests and our allies. But before the UK commits itself to a new war in Afghanistan, we think that Ben Wallace should be asked the following: how will the Ministry of Defence be held accountable when strikes go wrong? And finally, what recourse will Afghan civilians have when their loved ones are killed or injured? Thank you.
I think we're going to hand over to Gavin, but Georgia, you may have to stop sharing your screen.
Oh yeah, got it.
That would be great. Thank you so much, Georgia, and thank you to you as well, Ian. Let me start by saying 3 things. First of all, I have no PowerPoint slides. That is not a technical glitch. I've just decided to talk to you for a little while. Secondly, my young children are just outside this door, so you might have a chance to meet them shortly during our time together. But thirdly, let me say that I am really humbled speaking after Ian and Georgia. AOAB and Air Wars do extraordinary work on casualty recording. Because make no mistake, it is hard, demanding, and often really personally challenging work. So I really wanted to start by saying thanks to both of you and to your teams for the great work that you do. Now, as Matthew said, I'm the Executive Director of Every Casualty Counts, an NGO focused exclusively, some might say obsessively, on casualty recording. And at Every Casualty, our mission is simple: to ensure that every life lost to armed violence is recorded promptly, identified correctly, and acknowledged publicly. And there are 3 pillars to our approach in doing this. 1, we coordinate the Casualty Recorders Network, a network of around 50 casualty recording organizations operating in various contexts around the world. And I'm particularly delighted to say that that includes AOAB and Air Wars. Secondly, we provide technical assistance and promote the increased standardization of casualty recording. This follows on from the standards for casualty recording, which were first published in 2016. And thirdly, we advocate to generate global support for casualty recording from states, multilateral actors, UN, peers, and partners. This is both in generating the political will and ensuring that that will turns into implementation. So I joined Every Casualty earlier this year, and I have been impressed, surprised, and at times shocked by the approach that some states take to casualty recording, not least the UK. When the UK government says with a straight face that it has caused only one known civilian death after 1,700 airstrikes, it's hard to know whether to laugh with incredulity or to cry with despair. Now, for me, for every casualty, casualty recording is ultimately about dignity. Respecting the dignity of the dead is one of humanity's most universal values, shared across cultures, religions, geographies. And while the customs may vary, the personal, societal, and indeed the legal need to acknowledge an individual's death is common worldwide. Earlier this year, we actually tweaked our organization's name to Every Casualty Counts to emphasize this value we put on each and every person, on each and every life lost to armed violence. So casualty recording then is the process of systematically investigating, recording, and documenting all deaths in a given context of armed conflict or violence. And that casualty recording is carried out by individuals, civil society organizations, state authorities, and other actors, including the United Nations. And a defining feature of casualty recording is its focus on identifying deceased individuals personally and in as much detail as possible. This process of investigating and documenting large numbers of deaths in such depth can take many years. And it's also about rights. We see casualty recording as a tool to enable states, including the UK, to fulfill their human rights obligations, as the excellent report being launched this evening recognises. Casualty recording touches on so many fundamental human rights. Comprehensive, accurate, detailed casualty records are essential for survivors to claim their rights of inheritance, state financial support, or compensation. They're particularly important for women and girls, who all too often need evidence of a male relative's death in order to access their economic, social, and cultural rights. For instance, widows may become permanently destitute if they're unable to prove their status and to remarry. Casualty recording is also crucial for accounting for missing persons in armed conflict, again, as tonight's report recognises. Thousands of people are reported as missing because their bodies were not identified, so their deaths could not be recorded. Without adequate information about a loved one's death, families can only register them as missing or disappeared. Similarly, without effective casualty recording to identify and locate the dead, survivors are denied the right to give their loved ones a burial in accordance with their religion or belief. Casualty records help uphold the right to life by providing essential evidence for investigations, both civil and criminal, into possible violations. Without the detailed information contained within casualty records, survivors may never be able to effectively realise their right to know the truth about the fate of their relatives. The wider efforts to ensure accountability and prevent impunity are hampered without such evidence, and the right to remedy is also jeopardised as a result. Justice, reconciliation, and memorialisation processes, both formal and informal, cannot be meaningful and effective without a full understanding of the facts. So at Every Casualty, we call for explicit recognition of states' obligations to support, facilitate, conduct, casualty recording in all relevant situations. And this call goes out to the UK government. Excellent casualty recording initiatives already exist in many places, covering many conflicts, led by civil society, states, UN actors, and others. But the problem is that they remain ad hoc, underfunded, and underutilized. We call for states to ensure that comprehensive, consistent, effective casualty recording is conducted in all relevant contexts every time. We simply believe it must be a fundamental part of states' responses to situations of armed violence. This recognition of casualty recording obligations in principle must, of course, be joined by efforts to make them effective in practice. Now, if I may turn to Syria for a moment, which I know the report uses as its primary context, while its lessons are necessarily wider. Last month, the UN Human Rights Council in Geneva was briefed by the High Commissioner for Human Rights on her office's data on fatalities in the Syrian conflict. It was the first time the Council had asked for such figures since 2014. And part of the point of doing this, I get, was to generate renewed urgencies on a conflict which has been running now for over 10 years. I remember being in Lebanon on the 3-year anniversary of the Syrian conflict and feeling outraged it had gone on that long. Now, both the Independent International Commission of Inquiry on Syria and OHCHR do work with casualty recording organizations in Syria and elsewhere to document and investigate fatalities. It was this collective information, together with their own data sources and the limited information shared by the Syrian government, that was used to produce the High Commissioner's briefing. And while undertaking this briefing, High Commissioner Bachelet made clear that the fatality figure she quoted was certainly an undercount and is not, and should not be seen as, a complete number of conflict-related killings in Syria. In fact, contrary to headlines in the global media, the figure was not even presented as a benchmark minimum number of deaths. Rather, the figure quoted was the minimum number of individuals killed in the Syrian conflict, which OHCHR and its partners have been able to identify and to verify by full name, date, and location of death. Any death for which one or more of these pieces of data were not available could not be included in the report. Now, in an ongoing conflict like in Syria, these 3 deceptively simple criteria automatically exclude tens of thousands of deaths from the records. Many researchers believe that fewer than half of the conflict's casualties can currently be accounted for using these standards. People who've gone missing, disappeared, or died on the journey to seek asylum elsewhere are also left out. And it's this disconnect which illustrates an important and possibly widespread misunderstanding about what casualty recording actually is, and what it can and what it can't reveal. Casualty recorders, I know, work meticulously to document, identify, and acknowledge the individuals killed in conflict in as much detail as possible. They aim to document the fate of identifiable people wherever possible, not only to produce statistics. And in practice, it can take decades before the details of a particular death are fully known. In Syria, many deaths occur in secret locations, isolated areas, or in bombardments so intense that no identifiable human bodies remain. It is simply not yet possible to produce a comprehensive account of the death toll, and certainly no reputable casualty recording organization has claimed to do so. But the point of casualty recording, to recognize the unique humanity of each person killed, is lost as soon as the debate becomes simply an argument about numbers. and indeed, if I may step into the controversial, discussing human lives in purely numerical terms, which I know nobody here would do, has echoes of the deliberate dehumanizing processes which facilitate genocides and other mass killings. Now, of course, in situations where large numbers of casualties have been recorded, it is possible to develop high-level statistics. Of course it is. However, this data crunching is a byproduct of the recording process rather than its purpose. I see the real value of casualty recording as qualitative, not quantitative. Every documented death can help surviving family members to access a war pension, claim an inheritance, seek a criminal prosecution, obtain compensation, or simply ensure a dignified acknowledgement of their loved one's fate. Casualty recording cannot bring the dead back to life. But when properly resourced, conducted to recognized standards and used appropriately, it can restore the dignity of the deceased and the rights of the survivors. Let me finish up with the words of the Croatian ambassador to the UN in Geneva, Ambassador Kos, who has been doing a great job leading calls for greater global support for casualty recording among member states, and is one of the leaders of a core group of just over 50 states who are promoting casualty recording and have shown themselves to be very committed. She says, Croatia suffered the direct impacts of conflict during the homeland war of the 1990s. From this experience, we have learned the importance of casualty recording and its role in the effective realization of many fundamental human rights, as well as reconciliation efforts. One of the most important lessons of Croatia's experience is that casualty recording is not just about documenting the number of casualties, but rather about acknowledging each person's identity and fate. Done properly, casualty recording relieves families from the torture of not knowing the fate of their loved ones. Thank you.
Thank you, Gavin, and Ian and Georgia, for that very impactful series of presentations. I think it's easy to read a news report of an airstrike and perhaps be shocked by the report of civilian deaths, but I think so rarely does the public think about the difficulty of actually obtaining those figures. And of course, Gavin, as you said, the lives behind them. And it's still incredible to me that much of this work still has to be done by NGOs or private actors, not in an organised manner or a coordinated manner, often by state actors. So it's against this background that the CPP partnered back in 2019 with Ian Overton and Action on Armed Violence. And you should hopefully be able to see my slides now. I think they are up. Katya, you'll let me know if it's not working. Okay, I'll take silence as a yes.
It's working, thank you, Matt.
And the aim of the CPP's work really was to conduct a detailed audit of the legal landscape that might apply to civilian casualty recording. And I should say at this point that by casualty, at least for the purpose of our research, we refer only to deaths, and that was a necessary limitation on the scale of the work. But of course, civilian harm can manifest in myriad other ways. So the object of the Cambridge research really was to draw together a detailed encyclopedia of the different ways in which the law has something to say on the need for the UK to investigate, record and report civilian deaths. And whereas previous work, of which there was much, had tended to focus on international humanitarian law, often called the laws of war, or international human rights law, this report also looked at domestic UK public law, which is an area where consideration of this topic has been lacking, as Georgia has said. And so the idea ultimately was not only to gather information, but to assess the claim of the UK government that it was under little legal obligation to do more in this field. And so that report, which was produced by a team of 12 Cambridge researchers, and I can see some of them tonight in the participants list, and which was supervised by senior members of faculty. That report is now published and is live on our website. We'll put the link in the chat shortly, and we'll also tweet the link to the report. So if Ian, Georgia and Gavin really presented the reality of the situation on the ground, the Cambridge legal audit really presents the opposing legal ideal. What has the UK actually signed up to do? And so at the highest possible level, we will now spend about 10 minutes looking at what some of those legal norms are, and we'll then open up to a Q&A. So please post your questions in the Q&A box. So the research teams split their work into 3 silos. The first looked at domestic UK public law. That's the law of UK statutes, the UK Constitution, the UK common law. The second silo looked at international humanitarian law, and the third at international human rights law. So on UK law, in the UK, the types of problems identified by Georgia and Gavin have been known really for some time. For example, in the 2016 report into the Iraq War, what was called the Chilcot Report, you can see on the slides here that it was found by the inquiry, among many other things, that government certainly has a responsibility to make every reasonable effort to understand the likely and actual effects of its military actions on civilian. But it was concluded by the inquiry that greater efforts should have been made by the MOD to determine the number of civilian casualties. And it was also found by the inquiry that over the course of evidence before that inquiry, the government's line remained that the UK, quote, had no means of ascertaining the number of Iraqi civilians who had been killed. Importantly, in evidence before the inquiry, and I'm quoting, the government did not consider that it had a legal obligation to count civilian deaths. And this really was the flavour of the evidence before the other committees and inquiries that I list here on this slide. This, of course, is against the backdrop of what Ian said, which is that the official line is still that airstrikes in Syria only killed 1 civilian. So the essential problem, at least domestically, is that it's often understood that the UK's responsibility to record casualties in the UK is purely political or moral. It said, you know, sure, there are these international obligations, but at home, many of these aren't enforceable. As Georgia said, there's no act, as there is in the US, or no convention to record these casualties. And so the view is that there's no direct legal obligation at home to record and report. Well, the Cambridge legal audit perhaps casts a slightly different light on that assumption, and by way of incredible generality and overview, there are really 3 areas where UK legal principles might have something more to say. And this may be familiar to the public lawyers in the audience tonight. So the first is the constitutional principle of accountability. And it's one that's often forgotten, but it's one that's incredibly important. And this is the idea that ministers and government are accountable to Parliament for the conduct of their departments and agents. And in modern practice, what this means is that government must disclose to Parliament an adequate amount of information in order that Parliament be able to fulfil its function of holding government to account. In an extreme and rather well publicised example in 2019, when Boris Johnson prorogued or suspended Parliament in order to avoid oversight of certain Brexit arrangements, that action was considered unlawful because it impeded this constitutional principle of accountability. Now, in less extreme cases, this convention of accountability is enforced politically. But the prorogation case shows us that this principle of accountability can, in some cases, find a voice as a binding legal standard. And in the case of armed conflict, there is certainly, at the very least, a constitutional requirement that Parliament be furnished with adequate and accurate information about the conduct of the conflict, and this includes deaths. And it's been acknowledged by successive parliamentary reports, which I list here, that this has not always been discharged. So at the highest level of generality, the Constitution has something to say about the necessary furnishing of information. The second basis is the doctrine of legitimate expectations. In summary, on one reading of the cases, it is possible that the international treaty obligations that the UK enters into concerning civilian casualty recording, coupled with statements from government and the MOD, might create an enforceable expectation that government deliver on those promises to record casualties. No one's tested this argument yet. It's relatively new, but similar arguments have been run in the context of consular assistance in the context of armed conflict. And finally, and this is perhaps less controversial, it has been understood by a number of judges that the common law, the English common law, can take in norms of customary international law. So to the extent that there are customary international norms out there which say, well, the international community says you have to record civilian deaths, those customary norms might actually be brought into the common law and provide some actionable basis. There's also the Human Rights Act and human rights law, but we'll address that separately in just a moment. So no doubt these mechanisms fall short of the sort of legislation which Georgia envisages, but the view that British law has nothing to say on the question of gathering this information is perhaps more nuanced than might be supposed. So that's at a very high level. The next question really is, well, what are these international norms? And here I'll hand over to my fellow Cambridge graduate, who's now working at Freshfields, Tom Marshall. Thanks, Tom.
Thank you, Matt. So because you said I'm working at Freshfields, I just want to say that this has no relation to my work whatsoever, and I'm doing that on purely personal basis. So in terms of international humanitarian law, there's nothing really groundbreaking here. There are lots of surveys out there that have already talked about this issue and that have already kind of listed all the existing obligations in respect of the obligation to record civilian casualties under international humanitarian law. So there is no formal obligation to record civilian casualties as such, but there are elements of an obligation to record civilian casualties which have been spread out across the different international legal sources that we have. So the first one would be the Geneva Conventions and their additional protocols. Geneva Convention number 4 contains an obligation to search for the civilians killed and wounded. Additional Protocol 1 specifies that the implementation of the protocol and the activities of parties to a conflict must always be guided by the right of the families to know the fate of their relatives. There is also an obligation to search for the missing and the dead and identify and recover the dead from battlefields. And of course, in Additional Protocol 2, we also have a succinct obligation to search for the dead. So taken together, these rules provide some kind of framework to record civilian casualties. This is also confirmed by customary international law, with the two major rules being Rule 116, which provides that the parties to a conflict must identify the dead and record all information relating to the deceased, and Rule 117, which provides that parties to conflict must account for those reported missing. These rules of international law are, of course, implemented in the UK Joint Service Manual on the Law of Armed Conflict, but the question is, for us, whether the UK is actually complied with these rules and actually follows these rules and the spirit of these rules, which is that there is an obligation to record civilian casualties in international law, even if not formally stated, and this obligation must be respected, implemented, and given effect. So the purpose of recording civilian casualties is also to comply with other rules of international law, and those rules are the rules protecting civilians during armed conflict. The protection of civilians during armed conflict is organized around 4 major rules. So the prohibition on directing attacks against civilians, the prohibition of indiscriminate attacks, the prohibition of disproportionate attacks, and the obligation to take feasible precautions. And now these rules always require some assessment of the presence of civilians in the vicinity of military operations. And the conduct of proportionality assessments in the context of the prohibition on disproportionate attacks, of course, require an assessment of the presence of civilians in the vicinity of a military operation prior to an attack. And the fact is that without an obligation to record civilian casualties, without an actual tracking and recording, a thorough tracking and recording activity, there is no way that the parties to a conflict will be able to actually implement these rules properly. So the purpose of having an obligation to record and having a recording system is to make sure that parties to a conflict actually comply with their obligations under international law, under international humanitarian law, and to give effect to these rules, which are intended to limit the number of civilian casualties during armed conflict. And finally, one of the last purposes, and also a very important one for the obligation to record civilian casualties, is linked to the state obligation to investigate violations of international humanitarian law and war crimes. Because without an obligation to record civilian casualties, there's no way that a state can actually keep track of the activities of its military or combatants. And part of the purpose of the obligation to record civilian casualties and having a recording system is to keep track of the number of casualties which may have been caused during armed conflicts, and if necessary, open investigations and monitor the activities of armed forces to make sure that they again comply with their obligations under international humanitarian law. So those 3 major pillars of the obligation to record civilian casualties actually show that even though not formally stated, there is a need for an obligation to record civilian casualties, and that there is indeed a framework for an obligation to record under international humanitarian law. And now I will give the microphone to Katja to give us the human rights law perspective.
Thank you very much, Tom. So last but not least, we'll get to the UK's obligations to record and report civilian casualties under international human rights law. In the report, I address a number of preliminary questions which arise when we look at the application of international humanitarian law. And I would, for the purpose of this very short presentation, just like to focus on one, which is the issue of the extraterritoriality of human rights obligations. As most of you will surely know and be well aware, the presently particularly relevant human rights instrument, so that is the European Convention of Human Rights and the International Covenant on Civil and Political Rights, limit the scope of states' human rights obligations to their jurisdiction, and jurisdiction has thereby traditionally been territorially defined. Accordingly, whether the carrying out of airstrikes overseas brings the individuals affected thereby under the jurisdiction of the states carrying out such strikes is highly controversial. However, and this is important to emphasize, the European Court of Human Rights has recently, in the Hanan versus Germany judgment, affirmed that a state has an obligation under Article 2 of the Convention to investigate a death which has occurred outside its territorial jurisdiction, so extraterritorially, where there are special features that establish a jurisdictional link. Such special features establishing a jurisdictional link include the allegations of war crimes having been committed, which a state is under an obligation under international humanitarian law to investigate. So, as implied by these comments under international humanitarian law, under international human rights law, there is indeed an obligation of states. States indeed have an obligation to investigate and by implication to record civilian casualties to which a jurisdictional link can be established. Importantly, these obligations apply both in the context of an international or a non-international armed conflict, as well as outside designated areas of armed conflict. As Gavin so brilliantly mentioned before, there's numerous rights which may serve as a basis for such an obligation, and I'm just mentioning the most important ones here. The most important one certainly is the right to life. So the right to life obliges states to investigate deaths caused by a use of force within their jurisdiction. Other relevant human rights are the prohibition of cruel, inhuman, or degrading treatment, the right to family life and unity, and the right to an effective remedy. The standard of investigation required is thereby sensitive to operational constraints. As the European Court of Human Rights noted in its Ahmed Özkan and others versus Turkey decision, while it is mindful of the fact that loss of life is a tragic and frequent occurrence in the security situation in Southeast Turkey, neither the prevalence of violent armed clashes nor the high incidence of fatalities can displace the obligation under Article 2 to ensure an effective and independent investigation conducted into deaths. Accordingly, under international human rights law, an investigation following the use of force may not be reduced to a mere formality. The European Court of Human Rights has notably required states to undertake all reasonable steps to secure evidence concerning an incident resulting in a suspected violation of the right to life. This, according to the court, includes the collection of eyewitness testimony, forensic evidence, and where appropriate, an autopsy. So-called fog of war arguments are thereby generally dismissed by the court. Now, finally, and separately, the obligation to publicly report the number of civilian casualties can be based on the right to access information. The right to access information is the passive limb of the right to freedom of expression, and it obliges the UK government to truthfully, accurately, and publicly report the number of civilian casualties caused by its use of force. Importantly, it has been generally acknowledged that the alleged violation of human rights engages a high presumption of disclosure. Information on potential human rights violations may accordingly also not be withheld on national security grounds in a manner that would prevent accountability for such violations or deprive a victim of access to an effective remedy. So this is very briefly the human rights perspective on the obligation to investigate, record, and report civilian casualties. And I'll now hand over back to Matthew, who will open the Q&A session. Thank you very much, Matthew.
Thank you, Katja. And thank you once again to all of our excellent speakers. We have glossed over what is a 120-something page document, but it's now live, and it really is our hope that, dull and lawyerly though it may be, a thorough documentation of all of the relevant norms in one place might hopefully be of some practical use to Gavin, Georgia, Ian, and the many others who do the excellent work that they do. So we'll now open up to questions. I can moderate the questions. I think the first one really could be answered by any of Gavin, Georgia, and Ian. It comes from Alex, and Alex says that I assume that underreporting of civilian casualties may be motivated by a desire to avoid any liability on the government's part for those deaths. Alongside recent calls to reform or repeal the Human Rights Act, there has been some pushback against extraterritoriality under the Human Rights Act. So her question is, how do you manage the tension between encouraging accurate recording and a political climate where human rights increasingly seems to become akin to a dirty word. Ian, Gavin, Georgia, would you like to field that?
I can just have a few comments. The liability issue is very interesting. So we looked at civilians killed or injured in Afghanistan by British forces, and they published at some point relatively full details in 2010, for instance, how many civilians had been given money for incidents that occur, anything from the destruction of property through to fatalities. And there were, around the entire period, we found 286 civilians who had been killed in incidents where the MOD accepted enough liability, so to speak, that they would pay up compensation, but they did not actually accept liability, saying that they were their actions had led to such deaths. And there was this sort of almost Kafkaesque moment where they were saying, yes, we paid £2,500, or we killed 4 children, or 4 children died and £10,000 was spent out on this. But they would not at the same token admit at any stage that they were responsible for those deaths. Alongside this, in terms of accountability, comes a really problematic issue in that many countries where airstrikes are being used or British troops are on the ground, the local population increasingly becomes hostile to Westerners, arguably. And as a journalist, I've been chased out of towns because people think I must be some spy or something. And so even trying to defend human rights in certain environments, you may come up against a Salafist jihadist who wants to kill you. So there is a real problem about who ends up accurately recording. I don't have an exact answer in terms of the Human Rights Act itself, and that might be for someone else. But I think there is this general reluctance across the board, in a way, of the MOD to accept any culpability. And I think this isn't just about liability. I think it's also about an institutional framing that the British military are the good guys. And they do not want to contemplate the fact that they may be responsible for 286 civilian deaths, and that's a lower figure. And there's certainly a kind of a heroic value that you get in the British military framing themselves as doing, good, honest work. And this is a profound psychological problem for a lot of troops. And I would believe, actually, in some strange way, that the civilian harm that's been witnessed by troops in the last 20 years has also fueled what I think is a PTSD crisis amongst British veterans that we're seeing existing today in British society.
Then, Matthew, if I may just add to Ian's brilliant analysis there, and on the question of how do you engage, how can we engage in a UK government in which is deliberately shrinking civil society space, and how do we do what we can in that space? And the real answer to your question is it's really difficult. It is pretty tough, and particularly after, I've been, I suppose, involved in this kind of thing for 20 years, and it's very much a period of two halves. One half in which there was a lot of encouragement, a lot of engagement, a lot of access, a lot of willingness and interest around ideas, and about how do we do things better. And over the last few years, we have seen that get harder. And as you say, we hear the language of rights right up to is the UK going to withdraw from the Human Rights Act and replace it with our own version? But how we go about that makes our job even more important. It makes it harder, but it's more important. And some of what we need to do is we tie it in with what is already happening, so agendas that are happening. So, for instance, the protection of civilians, that is part of a global and a UK movement of organisations. And within that, we have to hold the UK government to account in that, politically, through meetings, through some of the rather dull bread and butter work of advocacy, relationship building, and influence. But it's also using things like the integrated review. The integrated review, lauded as being the biggest look at foreign defence development policy in a generation, and how within that framing can we highlight the fact that it says essentially nothing on the protection of civilians, on casualty recording, and to highlight and show that we are building momentum globally around casualty recording, and the UK needs to get on board with that. So there are some really positive, and I promise there are some really promising signs of momentum globally on casualty recording. And it is about how we dock the UK into that and sort of inspire action within that context.
Yeah, and I would just quickly add to that as well, is that just for air wars, so we're a monitoring organisation. So what's really important for us is that we use the same methodology for every single conflict, every single belligerent, and then this is our findings. It means that that's what we can take and show every single Ministry of Defence. And also it's really important for us that we don't take any sides in conflicts that we monitor as well.
Thank you, Ian, Georgia, and Gavin. We've got time for a couple more questions. We've got one from Serhi, and this is one that might be answered by any number of our panelists. And the question is, what is the actual CIVCAS, or civilian casualty management model used by the British troops on the ground? Is its use trained at the military exercises before the deployment? Is there any synergy with the CIVCAV management model recommended by the NATO Handbook on Protection of Civilians? It's quite a specific question, maybe targeted more to those with knowledge of military practice. But I think the general question more is, how has the UK and how do the US, when they do not rely on the likes of air wars or AOAV, how do they conduct their own investigations? Is it done ad hoc?
I can address. So I was at the world's largest arms fair, or Britain's largest arms fair, the DSEI, the other day, and I saw the chief of the general staff there, and I rushed up to him and I asked him basically about responsibilities of casualty recounting, and he said, we follow the rule of law. And as he sort of rushed off down the corridor, I was sort of shouting after him, but how do you know if you don't count the civilians? But he didn't really want to engage in that. When you try and interrogate this from a British military perspective and try and work out what they do and how they do it, you run up very quickly against a refusal to show you that information and that process, because they claim that it would be basically it becomes a defense and security issue under freedom of information. So there's this kind of strange standoff that we know the British military do not have a standalone casualty recording unit. Obviously, when and we equally know that the MOD do not routinely capture and record civilian casualties as a consequence of their missions. So what you end up is SITREP reports, battalion reports that summarize when civilians are killed. But the other day, I was looking at 4 children killed in a single incident where the British MOD paid out money. But I cross-referenced that with leaked documents from battalion reports that occurred in Helmand province in 2010, and not one of them mentioned 4 dead children. And so my point is, if you can't even get to 4 dead children, hitting a point where people actually report it internally, then there's very little hope, I think, that there will be a more comprehensive structure adhered to with this culture of denial.
Thank you, Ian. I think, Georgia,
Yeah, I was just going to quickly add that that's definitely a question that we all want to know as well, is exactly what the mechanisms are. And yeah, so like, for example, the UK has actually endorsed the recommendations, some of the recommendations in the NATO handbook, as we saw in the approach to the protection of civilians from the Foreign Office. There were kind of commitments to investigate. But yeah, it's kind of the granular details of how this is going to happen and how it's happening, and whether they'll publish assessments on action that has been taken. And that's definitely information that is really important for us to know. We don't know at the stage.
Thank you, Ian and Georgia. We have another question from an audience member. This is from Andrew Kenning, and Andrew asks, with civilian harm by air power becoming increasingly caused by algorithmic target identification, which seeks to attribute combatant status to surveilled civilian populations, should the starting point be with pursuing accountability and responsibility on those who design such targeting programs? Because often casualties aren't an accident or a mistake, but an internal feature of these mechanisms. Ian, I can see you nodding your head. Perhaps you'd like to start off with the answers.
Well, I mean, one of the salient features I thought when I went to the DSEI, the arms trade fair, I spent a lot of time talking to people who were very, very excited about AI. And the thing I saw from a sort of a distance perspective is every single one of them was a middle-aged white man. And they bring an internal bias to that. Another salient feature of a lot of drone strikes is that, you know, there is this cross the board thing. If you're between 16 and 24 years old in Somalia, for instance, that there's a very real chance that you will just be dismissed as a combatant simply because of your age and your presence on the battlefield. So I think you've got bias in programming, you've got bias in intel, you have bias in, war is inherently an othering of the enemy. And there's a diminishment of that as well. So there is false assumptions. People will always assume the worst. You may be a threat where you're no threat at all, according to this. So I think there's a very, very problematic issue emerging here with relation to particularly autonomous robotic systems or semi-autonomous robotic systems. It's rooted in potentially biased programming and questions about moral, ethical, and officerial control in the military control, and the chain of command and ultimate responsibility is problematic. And very finally, the same principle as who do you sue if a self-driving car runs someone down? Do you sue the programmer? Do you sue the owner of the car? Do you sue the manufacturer? Who do you sue? It is something that, you know, will come into this. And I think that ultimately this leads to even a further inability to properly scrutinize and hold individuals to account. And there hasn't been one leading officer in the last 20 years in the British military who has had to face any kind of line of inquiry as to whether they killed civilians or not, owing to poor command structure.
Thank you, Ian. I think we've got time for maybe two more questions. This is a question that I think perhaps touches on the point of dignity, which Gavin so brilliantly raised in his talk. And this comes from Nishant, who's a fellow PhD researcher here at Cambridge. And Nishant asks, outside the legal discourse, are there efforts being undertaken by public institutions, and he says like the Imperial War Museum, to represent the outcomes of these asymmetrical military actions? Or otherwise put, are there efforts within civil society to memorialize or to understand this hidden cost of war? That seems an important political aspect of getting the will for change. Ian, Georgia, Gavin.
I would firstly cheekily plug the recent investigations by Air Wars, which a lot of them are kind of to map these in different ways, but also by the work of organizations like Forensic Architecture, which aim to kind of use methods of research architecture and design to display their findings in in a way. So yeah, that's what I would say.
Yeah, that I would add to that. There are some efforts, although I think it's something that I'd kind of be really interested to explore more about the memorialization point. HI has been doing some pretty interesting work in this space. For instance, sorry, that's humanity and inclusion, in which they unveiled the tomb of the unknown civilian, which, you know, when you're getting the kind of stats that Ian and George are talking about, the sheer scale of civilian casualties from armed violence and armed conflict. As soon as I saw that, I thought that makes complete sense. Why are we not seeing much more of this? So I think there are efforts out there, but also I think that's an area in which we could do considerably more.
Largely, I find that the memorial landscape in the UK is very much dominated by kind of the state, by ones who will memorialise those killed primarily serving the state, the military, etc. It sounds silly, but there's no national memorial for women killed accused of witchcraft in the medieval period. There's no national memorial for women killed as part of domestic violence. There's no national memorial there are memorials for things like victims of the Blitz, but there's no national memorial for victims killed as a consequence of British military action. So this is a problematic framing. And I've tried to get in and sort of analyze what you would need to submit a memorial. And to be honest, it's very hard even to know where to start. Who are the right people to ask? Can you access them? What is the process? Where can you establish funding from? All of these things coalesce where you don't have easy mechanisms. And I think, as Gavin said earlier, civil society is being thinned out, with the exception of military charities. Military charities sit on hundreds of millions of pounds because they get the goodwill of the people. Help for Heroes has had lots of amounts of people. Now, this is lots of amount of money. This isn't necessarily a bad thing. I'm not criticizing it, but the civilians are almost the absent debate in all of this, because civilians are over there. They're not here. Our civilians, so to speak, aren't being killed. But when you get things like the 7/7 bombing or the Manchester bombing, you both get ad hoc memorials and state memorials in response to those atrocities. But we don't really contemplate the harm that we mete out.
Thank you, Ian, Georgia, and Gavin. Well, we've got time really for one final question. There are a number of questions that touch on that common theme of what more can we do if there is this gulf between the legal reality and what is actually happening on the ground? How can we be leaders? Perhaps put more pointedly, NGOs and international organisations will publish things like the standards for casualty recording, which came out in 2016. These are meant to be, I guess, common standards for how you do the sort of work that Gavin, Georgia, and Ian, you have described. How useful are standards like this? How responsive are governments? Are we publishing these as wishful thinking, or are we actually changing the reality on the ground? And I'm hoping the answer will be a happy one, but we might finish with that question.
It feels only appropriate that I come in on that one. Thank you for that, Matthew. The brilliant thing about the standards are the fact that it is not just a straight cookie cutter approach. It's not just, you must do all of this, because one of the things, and Georgia and Ian will speak more eloquently to this, is context is all. There is so much about the context in terms of what is possible, in terms of access, in terms of the sources of data and the verifiable data determines to some degree what you can and cannot do. But the standards talk in terms of musts and shoulds, and those can be kind of tailored to specific contexts. Now, have we just created some standards and that has led to no change? I think I can give you a much more positive answer on that. And actually, to pick up one of the questions of earlier, in terms of how does the UK go about in its military operations, I was just double checking that the NATO Protection of Civilians handbook now has explicit reference to the standards, as does OHCHR's guidance for casualty recording. Now, I think we can accelerate that. I think we can do much more of that. I think it's one thing to create standards. It's then another to really promote them, embed them, update them, develop them. Those things are clearly things that are going to be required in there. But we are, together with many of the people in this call, building momentum, and building momentum particularly globally, because there is now a core group of over 50 states saying casualty recording is a good and great thing and needs to be done. Some who have done just the most extraordinary casualty recording themselves, thinking about the Kosovo Memory Book, for example, here, one of many, many volumes of that. And when you've got advocates who are states themselves saying this has been of value to us, and that the things like the standards have been created with casualty recorders, not just by somebody sitting in a room on their own thinking great thoughts, but actually going, this is lived experience, and this is what can help and support in what quality casualty recording looks like. Then I think the answer is yes, we can make, they are worth it. We need to do more, and we need to do more, and we need to be thinking more about kind of the standardizing of the processes and of the way the information is handled, so that there can be, we can rule out some duplications. We can support casualty recorders who are getting up and running, for example, because this thing is so dynamic, because conflicts are kicking off, and we need to be able to support those people. There is a natural human desire, I believe, to casualty record, and to be able to help and support in doing that. I think things like the standards, but making them really practical, is definitely the way forward.
Thank you, Gavin. Ian.
Yeah, I would just like you made one point about what can people do. It sounds silly, but potentially you could just take this PDF that you've produced and email your local MP. It will take a few minutes of your time, but if 40 of us did it, we may hit 40 MPs. We may email 3 MPs. Tweet it, distribute it. Spend an hour just sending emails out, if you really want to. I think it's about engagement, and I think it needs to be more than just liking something on a Twitter account. It needs to be absolutely taking something and articulating it, writing a letter. If you're a journalist listening in, reporting on this issue. If you're a lawyer listening in, offer pro bono work to groups like Air Wars or Every Casualty or ourselves. I mean, there are legitimate things you can do. There are small things and there are big things. Donate some funds. All these things are possible. But I think on a very simple level, trying to amplify this report as much as possible would be just really useful, and make sure that the small group of us who are trying to get it out just becomes a bigger group, and that would be immeasurably helpful. So please tweet it, please email it.
Yeah, I would also just add to everything that Ian and Gavin said, but also just that we've seen meaningful improvement when there has been meaningful engagement with civil society organizations, with governments, and so things also can change. So yeah, I would just reiterate what Ian and Gavin said about engagement is really important in this issue.
Thank you, Georgia, Gavin and Ian. I think that's time for us, but it has been an absolute privilege for Cambridge to host all 3 of you tonight, and a privilege to prepare this report. One other way that you can share all of this is by YouTube, because for those who couldn't make it tonight, or for those who wish to rewatch this panel, it will be published in the next couple of days on the Cambridge University Law Faculty YouTube. So if you Google Cambridge University Law YouTube, you will be able to find a recording of this. So please share it with friends, colleagues, anyone who couldn't come tonight. And otherwise, look out for our next talk on Twitter. Once again, thank you for coming.
Thank you all. And thank you very much for doing this. I can't tell you how wonderful this has been. Thank you.
Thank you, Ian.
Thank you, everyone.
Thank you.